Good morning, everyone. We're going to go ahead and get started. We expect some members to be joining us shortly, but we do have a limited amount of time today. Thank you all for your flexibility and for being here. We're going to take up a bill that was cross-filed, but will, for today's purposes, just refer to it as House Bill 901. We've had several conversations with individual members on this bill. We had a very engaged public hearing on the bill and hadn't gotten to a point where we had the bill in a posture where we thought we were able to move it. And so wanted to have a conversation about what the bill as introduced does, and then talk about some potential amendments. Just have a conversation. There was a lot of testimony on both sides of the bill, and we just wanted to have an opportunity to hear and talk about what's in the bill and not diminish what the bill seeks to address. I think everyone that I've spoken to as it pertains to this piece of legislation understands the harm that the bill seeks to address, just trying to figure out what solution is the best solution for Maryland at this time and whether or not there's something that we can move forward. We're pleased we're going to have some members of the Finance Committee joining us today. And then we are also joined by the chair of the Economic Matters Committee. It's good to see you, Mr. Chair, and also the sponsor of the bill from the House side who's here, and then the sponsor of the Senate bill, who happens to be a member of Senate Finance. Good morning, Senator. And so what I thought we would do today is, and we're going to have some folks joining us virtually. If people want to come forward and sit in the table, sit on the side, you're welcome to do that. I think Senator Ellis will be coming. He sits next to Senator Mounts, so you may want to leave his chair open. But other than that, you all are welcome. Anyone who thinks you want to speak and participate is welcome to come up. What I'll say also before we get started is we initially were going to start at 8:30. We moved the start time to 9 when we learned the Senate wasn't going to be in session until 10:30. But then I forgot that there is a program honoring Barbara Oaks on the House side at 10 o'clock. So we're gonna have a finite amount of time this morning to discuss the bill. And if need be, we can reconvene if we need to have a follow-up conversation after this morning. So with that, I thought I would turn it over to our committee counsel, Patrick, and ask him to start with an overview of the bill as introduced, and then we can kind of just have a conversation. Does that make sense? All right.
Just try to provide a brief overview. So the bill requires a business that offers an online product likely to be accessed by children under the age of 18 to complete a data protection impact assessment of the product that includes certain elements such as identifying the purpose of the product, how the product uses children's personal information, identifies risks of material detriment to children that arise from data management practices of the business, and other factors such as whether algorithms are used by the online product, whether algorithms used by the online product could result in harm to children. This impact assessment must be completed by April 1st, 2025, and a business may not offer the product to the public before completing this assessment. The bill specifies that it's the intent that businesses should consider the best interests of children when designing, developing, and providing online products that children are likely to access when determining whether the action is in the best interests of a child. It has to consider the children's privacy, safety, physical health, and mental health. There are rules and procedures related to these data protection impact assessments. A business completing an impact assessment must maintain certain documentation, review the assessment every 2 years, and create a plan to mitigate or eliminate the risk of material detriment before the product is made available to children. There are also there is certain conduct that's prohibited by businesses, such as a prohibition on the use of personal information of a child in a way that the business knows or has reason to know is materially detrimental to the physical health, mental health, or well-being of a child. Business can't profile a child by default, with certain exceptions. And a business can't collect, sell, share, or retain any personal information that's unnecessary to provide an online product that a child is actively and knowingly engaged with, unless the business can demonstrate a compelling reason that doing so is in the best interests of children likely to access the online product. There's certain provisions that relate to enforcement. For example, within 3 days after receiving a written request from the Office of the Attorney General, a business that provides an online product likely to be accessed by children must provide the Attorney General with a list of all data impact assessments completed under the bill's requirements. And then within 5 days after receiving the request, the business has to provide the data protection impact assessment completed. If a business is in substantial compliance with the bill's requirements, the Office of the Attorney General must provide written notice before filing an action authorized by the bill. And a business may not be liable for a civil penalty for any violation for which notice is given if the business cures any violation specified in the notice within 90 days, provides the Attorney General with a written statement that the violations have been cured, and takes measures to prevent future violations that the Attorney General agrees to be sufficient. A violation of the bill is an unfair, abusive, or deceptive trade practice under the Maryland Consumer Protection Act and subject to its enforcement provisions. And a business that violates the bill's requirements is subject to a civil penalty of up to $2,500 per affected child for each negligent violation, and $7,500 per affected child for each intentional violation. Nothing in the bill may be interpreted to provide a private right of action.
Thank you, Patrick. Mr. Chairman, I didn't know if you wanted to say or give any opening remarks since you're here.
Just briefly, Madam Chair, my time is short because obviously we have a committee to run just like you do, and my memory is long. My confusion and concern obviously is that in this late of the, we've had 2 hearings, and it seems that every time we try to come to the middle, the opposition is steadily pulling away. And I'm hoping that this is a fruitful conversation, but my concern remains that if this stretches till tomorrow or Friday, then this bill is essentially dead. And I'm not sure, and I don't have a feeling that the opposition is actually moving in good faith. They continue to bombard us with amendments. So again, as I said, I know that there will be a time when I have to step away from this, and I believe it's in good hands because Senator Feldman's here, the good chair of the committee, as well as the sponsor of the bill. But I am not happy that it's in this posture. We've had several hearings, and to continue to get amendments well after both hearings is infuriating. There was an opportunity to move in good faith, and I think we've missed it. So I am going to be very interested, but I'm going to listen with a very keen ear on where this goes today. Thank you.
Thank you for those comments. Did you want to sponsor? And let me just say to everyone, for me, this is a topic that I have not spent years working on, and understand that there are those who have. Having heard the testimony from both sides in the hearing, I'm actually here hoping that we can make some progress on this. Legitimately believe that we have to take this topic very seriously, have plenty that we could do with this time that we have, Mr. Chairman, but really wanted to see if we can move the ball. So, Delegate?
Yeah, thank you, Madam Chair. I really appreciate the incredible level of thoughtfulness that you've put into this. And I want to thank Patrick as well, because I know we've bombarded you with lots of amendments at late hours. I think as the chair mentioned, we've done quite a bit, I think, to move the bill. And I want to recognize we're here with Google, who has actually come to the table. And I think as of last night, they are officially neutral. I think they're going to talk about the changes that we've made to the bill that, we've been working literally hand in glove with them. Again, apologies to Patrick up until the 11th hour to get to a place where we feel like this bill, obviously, to your point, and I know is your North Star, is protecting kids in a way that's incredibly responsible, but also is in a manner that allows tech to continue to innovate and allows tech to do it in a responsible manner. And I think that's what you're going to hear from Google. I just wanted to very quickly say, as we made a number of changes in the bill before it passed out of the House, I think to recognize the continued conversations that we were having, particularly a lot of local organizations in the state of Maryland. And I think most local groups are either in support of the bill or officially neutral based on the changes that we made coming out of the House. We further made a lot of changes to make it clear this was not a bill that was meant to be based anything around content. What you see when you go to a website, but that it was all about data management practices. And that's really the sort of the crux of what, frankly, we know is a mental health crisis, is causing a mental health crisis, or certainly a huge contributor to it in our young people. We've continued to work with, I think, any group that has been willing to come to the table with us. And again, I want to thank the team at Google. The amendments that we've got, I think reflect a really thoughtful approach from Google, from some of the other folks that we were working with to get to a place where they're comfortable with the bill. And then we've made additional other changes in conversations with other organizations to make it clear, to remove some of the vague pieces of the bill, narrow it a little bit more, again, still keeping the core of what protects children intact. And so, we're happy to walk through in whatever manner, you deem as appropriate. We've got some of the legal experts that are part of our team who know this stuff backwards and forwards, and we can walk through the amendments. We can walk through the reprint, however you all want to proceed.
Okay, I think that makes sense to walk through the amendments you have. Is there anyone who had anything pressing you needed to say before we do that part of the process? Okay, let's hear what you've got.
Great. Well, I'm actually going to turn it over to Marissa Shea, who's our legal expert, to sort of walk through the nuts and bolts. And again, I think probably just follow through on the reprint, and we can also share. We have a detailed bullet point by bullet point list of amendments too, because some of these have changed a little on the fly, which we apologize for, but it's just kind of the nature of what we were doing.
Good morning, committee chair and members. My name is Marissa Shea, and I'm working on behalf of the Five Rights Foundation. So as Delegate Solomon said, we are prepared to walk through the amendments. I'm happy to answer questions as I go, or whatever works best for this style of conversation. The first change that you should see in the reprint changes the whereases to the bill's preamble. This was done at the request of Google to ensure that even uncodified language could not be used by regulators or the court to misinterpret the bill as content moderation. We'll then move to section 144501, which is the definitions related to the code. Here, the first change is the addition of new language in C, where we're proposing a definition for the best interest of children. The definition here is based on a variety of feedback we received from industry, speaking to their desire to better understand what was meant by the best interest of children, so that it would ease compliance with the code and provide further details in terms of what they should be evaluating when completing their DPIA or otherwise seeking to.
Yep, Senator Kramer has a question.
Thank you.
Yes.
On that, so this is language that came from the industry, is that correct?
So the industry asked for a definition. There was language provided out of the Economic Matters Committee, which industry raised was perhaps more vague than no definition. So this new definition is actually looking sort of at what is used in terms of the duty of loyalty and some federal legislation.
I'm just looking at where it says best interest of children, and I see as part of that will not result in reasonably foreseeable and material. And then it has physical, financial, et cetera, harm to the child. I mean, is this language the industry wanted in there because it makes it impossible to enforce? I'm just a little curious about that.
I greatly appreciate that question, Senator Kramer. And no, we think this language is a strong definition that we worked on crafting with Five Rights, looking at some federal legislation and working with attorneys in the First Amendment constitutional law space.
Okay, thank you for that.
So then moving on, there's a variety of changes to this section of definitions. Most of them are renumbering the bill, or you'll see here lots of underlining that's actually reflecting changes out of ECM. So like the biometric information and other things are all in the bill in print. The
I would just add, again, we worked with a lot of groups while we were getting the bill ready for movement out of ECM. And so the underlined, but not italicized, reflects the amendments that we made in the Economic Matters Committee, again, to reflect what was, asks of industry to say, we want to make sure there's reasonable definitions in here. We want some clarity on pieces. So there was a lot of work that was done even before the bill came out of ECM to reflect work with stakeholders.
The next proposed definitional change that's new is going to be to L within this section. And there we're simplifying the definition of data protection impact assessment so that it clearly aligns with the best interest of the child. Rather
Page numbers by any chance?
page 6.
Thank you.
So there we strike mitigate risks to children who are reasonably likely to access the online product, data management practices, and instead clarify that the purpose of these assessments is that compliance with the duty to act in the best interest of the children. Moving on to page, I'm going to skip page 7 and go to page 8. Here, the text reflects an additional language to the definition of profiling. And I apologize for we're actually looking at putting this in a section of the bill that relates to the obligations under the DPIA. And that is drafting that we are waiting to get back on this morning. So we are looking at clarifying that profiling does not include processing of information that does not result in assessment or judgment about a natural person, as long as they're meeting the other requirements of the DPIA, versus just changing the definition. So it's again going to that implementation aspect of how these companies complete their DPIAs. Moving to page . This is where we're striking the determination that a business should make in the best interest of children, which was an amendment added in ECM to instead, we're swapping that for that definition in the definition section. Again, based on the feedback from industry that having it set up this way was potentially less clear than having no additional information for them to consider around best interest of the child.
Before we move on, one of the things I did want to call out, and again, this was a change we made before the bill came out of ECM. We moved the implementation date back to April 1st of 2025 to give businesses an 18-month window to come into compliance with this. So assuming the bill were to pass, the bill would take effect October 1st of this year, but then the actual compliance pieces of the bill would go into effect 18 months from there. And that was, again, in conversations with business, we wanted to make sure this bill is not meant to be punitive. It's meant to protect kids, but we have no private right of action. We have the 90-day cure period, and we really wanted to be very clear that, again, we wanted to be able to give business more than enough time. And it's very similar to the amount of time that was provided in the California legislation. So we bumped it back from July 1st of 2024, almost another year, to April 1st of 2025 to give businesses ample time to come into compliance with the new pieces of the bill.
So then moving on to page 15, what is currently numbered as section 144506, we're striking that a business must provide an online product likely to be accessed by children prior to offering the product to the public, as this was raised, excuse me, as potentially resulting in a prior restraint on speech. And because the bill contains the 90-day right to cure period, we feel that, comfortable with sort of the other requirements in the bill that clearly say for past and future products that are currently in play, these companies need to complete the DPIA process, while eliminate or attempting to eliminate that potential restraint concern. We make additional changes where we include reasonably likely throughout sort of the obligations on businesses, the data protection impact assessment. Again, trying to ease some concerns about vagueness related to children on their platforms and whether or not the code applies to them. And at the request of Google specifically, we looked at the 2 years for reviewing, or the requirement to review your DPIA every 2 years, and instead changed that to only when material changes occur to processing operations. This, hopefully again goes to that goal of the sponsor and stakeholders to be working with industry to make sure this bill is implementable, rather than placing sort of obligations at a set every 2-year marker. We want them to be evaluating their products as they make changes or as new products come out to ensure that they're complying with the intent of the code. That was still on 15. Yes.
25.
Yep, line 25. We strike, again, same page, line 27, the document any risk of material detriment to children that arises from the data management practice of the business identified in the assessment. We're again looking at, sort of clarifying this intent back to the best interest of the child and making sure that that is the standard that these businesses are seeking to comply with. And you'll see that in the change in line 30 and 31, where we say, they're creating and implementing a plan to ensure that the online product is designed and offered in a manner consistent with the best interest of children that are reasonably likely to access the online products. Moving to page 16. So here we add clarification regarding in response to I believe it's related. Thank you. Yeah, so we strike the enforced published terms of service, again, based on, overbreadth and vagueness concerns raised in the Net Choice lawsuit, trying to ensure consistency with enforcement. Sure, sorry. So we're looking at line 18 on page 16, and there we're striking the requirement that businesses enforce published terms, policies, and community standards. So this was a former requirement that was placed on companies after completing the DPIA to enforce their published, privacy policies, as raised by Net Choice in their lawsuit against the California Code and by industry stakeholders working in Maryland on this legislation. There's potential First Amendment concerns related to such requirements. Recent case law has interpreted the requirement that such terms of service be enforced as potential restraints, again, on speech. So we're striking that provision to address the concerns raised by industry to that regard. And then the next substantive change would be after line 23 on the same page, which says, see, a business that makes a good faith effort to comply with subsection B5 of this section is not liable for data processing, preferred while estimating the age of the child. So this was, again, brought up during our work with Google to this effect that if companies are, if they're off a little bit as the technology is being further developed in terms of how they're working on age estimation, that they will not be held liable for, being a year or two off in what they think their user is. And again, it's going back to sort of that good faith effort and how it works, how we see this working in with the right to cure and the sort of overall intent of the code to work with business in terms of, making the changes that we want to see to how young people interact with online platforms without, making it impossible for these companies to do the work they're currently doing.
Really important for us to make it clear, again, this is about working in good faith to keep kids safe. We heard that obviously from Google, but from a number of stakeholders that, well, what happens if we're off? We know age estimation is not a perfect process. We're not going to catch everybody. And so we wanted to make it again abundantly clear. This is if you're making a good faith attempt, you have an opportunity to work with the Attorney General to fix whatever problems arise. And we wanted to just sort of belts and suspender that.
So then, still on page 16, if you go down to line 25, we're inserting reasonably before likely. This was for the same reason as discussed before, where we're trying to give sort of additional clarity around who this applies to. And then, we're striking this material detrimental in line 28 and 29, and instead of replacing it with the need for or inconsistent with the best interest of children reasonably likely to access the online product. Here's changes to, I'm trying to remember if it's made in. So this is actually where you'll see the definitional change to profiling, and it's that we're not looking to
Page 16, sorry.
yeah, we're on page 16. Sorry, line 33. So we're ensuring that profiling is consistent with best interest of children reasonably likely to access the online product versus a sort of vaguer requirement that appropriate safeguards in place to protect children. So again, just trying to clarify that everything is going back to this best interest of children analysis and trying to provide further clarity for businesses and complying with the requirements of the code. The next change would be on the bottom of page 17, which again is striking material detrimental to the child's physical health, mental health, or well-being, and instead saying not in the best interest of children reasonably likely to access the product. On page 18, at the, through our conversations with Google, there was requests and these to change sort of the timeline for answering requests from the Attorney General's office in regards to providing their list of completed DPIAs. And so we're changing this from what was originally in the bill of 3 days to 5 business days. And then in terms of providing their data protection impact assessments versus just the list of what assessments they've completed, we've changed that from 5 to 7 days, but also provided the Attorney General's office with some flexibility to extend beyond those 7 days if, at their discretion, there is a reason to allow the business to have additional time to comply with their request. And that's, understanding that for some businesses, they may be requesting a variety of these DPIAs, or there could be certain circumstances that folks may want to consider sort of in the totality to determine the appropriate timeline. And then these other changes, then 14,509, now 14,508 were from the prior committee. So the next change specific to this is going to be that, yep. So we're going to go to the last page 20, and here, we're noting, again, just really trying to clarify that this is not content moderation, but rather about the design practices of these companies as they create these products, and that nothing in the subtitle may be interpreted to impose liability in a manner that is inconsistent with Section 230 of the United States Code, which applies specifically to limitations on content. And then our final amendments as related to this round, excuse me, of drafting, again, comes from our conversation and work with Google to ensure, that nothing in this bill is being interpreted to infringe on existing rights and freedoms of children. We're not trying to prevent them gaining access to important information online, just really trying rather to restructure how these products are developed, so that they're considering, children's privacy and their design. Thank you.
Thank you very much for that walkthrough, and thank you all for that work. I know we have someone from the Attorney General's office here, so I wanted to give you a chance to give feedback.
Thank you, Madam Chair and Chairman. Thank you. We're Steve Sakamoto Wengo with the Consumer Protection Division of the Attorney General's office, and we're generally supportive of the goals of the bill. However, I guess as Senator Kramer expressed, the way this bill was amended, it virtually ensures there's not going to be any kind of enforcement. The right to cure is something that we generally don't have in the consumer protection context. So you think if there is going to be a right to cure, that should be sunsetted at some point, because the businesses should be able to make those changes. We also, and I know that I'm a broken record on this issue, excluding the private right of action. We represent the state. And so, generally we would bring actions where there's a pattern or practice of, deception or other violations, but we can't represent individuals. So if there's an individual that's been harmed, they would need to be able to bring a private action. And so we have concerns about eliminating the private right of action. We also have questions about the penalty provision and how that interacts with the existing penalty provision under the Consumer Protection Act in 13-410. I know it says it excludes 13-410, but under 13-410, there are standards that we have to consider when assessing the amount of a civil penalty, including good faith, prior history of violations, and other factors. And if 13-410 is eliminated, do we then not apply those in determining whether there's a penalty here? So I think that would need to be clarified. I don't know that it needs to have its own provision. And then this is just, I guess, a technical thing that I've mentioned to Patrick. Page 19, lines 6 through 11. There is no commissioner. I'm not sure how that got in there, but the division or the Attorney General's office doesn't have a commissioner, so that would have to be either eliminated or or revised. So, but that's our concern, is that as far as enforcement, that the bill as drafted would make enforcement very unlikely or very difficult. So thank you.
Yes, Steve, with specificity, what is without addressing some of the other issues, what language makes the bill unenforceable? I also want, before I ask that, I understand that you said that the AG seldomly moves on behalf of an individual, but you got to see that the damage is being done to a class of individuals. It's not like one child and only one child is going to have been dealt with. That might be the genesis of the claim, but when there's a 13-year-old that is impacted, it's a class of people. This is just the one that came out, which is why we wanted the AG to be involved, because you are and will be protecting a class of people. That being said, with specificity, what is it that makes this, what you would consider, what language makes this unenforceable, and what would be a better better wording that would allow you to, as you feel, enforce this bill in a better way?
Well, I mean, like I said, the, inclusion of a right to cure, which, is going to make, much less likely that there's going to be enforcement, because the business is going to have, time to try to cure any violation. And then if they, just cure it, then they're off the hook.
I would say, I'm sorry.
I just want to ask how much time would there be if that provision were in there? What is a reasonable amount of time for?
The right to cure is in the bill currently, and it's 90 days.
It shouldn't.
We don't think it should include a right to cure.
And what
Yeah.
we're discussing is, and I appreciate that, because you
Right.
kind of mentioned that was, but in these large scale business and consumer movement, this is obviously a nationwide issue. If they cure it or you sue them, either way, the problem is solved, because the problem here isn't spanking somebody on the head, slapping somebody on the wrist, as much as it's getting these things out of the access of our children. So, and I appreciate that approach.
Yep,
That's what I was want to
Yeah.
be beside the
Yeah.
right to cure, because that one, I think that is a policy decision that this body will make
Right.
in determining what's more important, the punishment or just solving the problem. But beyond the right to cure, what other issues make this more difficult to enforce? Meaning, once the person is continuing to intentionally violate this law, goes outside the right to cure date, what else would make this difficult for you to enforce?
And also, I guess, the inclusion of language like good faith and reasonable all throughout the bill, it does make it more difficult to enforce. So.
We appreciate the work
Right.
that they've done, but I mean, the entire, I think, as we said from the outset, we have penalty provisions in here, obviously. We want to make this bill consistent. We know the AG's office has a long history of joining cases with other states. But first and foremost, the most important piece of this bill, as the chair said, this is not about punishing and figuring out a way to rack up giant fines. It's about working with industry to protect our young people. And so for us, the right to cure versus a private right of action, there was no question in our mind. It's not about punitive measures. It's not about attacking these organizations and these industries. It's about fixing the problems. And so the right to cure is that fundamental piece of how do we work together to fix the problems?
Yeah, thanks, Madam Chair. So I think with the right to cure provision, I'm a little concerned about, as we just heard, all of these additional clarifying, reasonably likely, possibly, perhaps, might, and then how do we get the AG to enforce that? We've got right to cure. So if somebody is doing something in violation of the statute, why not just let then the Attorney General say, you're in violation, here's what you have to do to cure? And I agree, we just want them complying. But we also have to be able to let them get at the act so that they can be required to comply. And with this reasonably likely that has been inserted throughout, we're going to find that, every time the Attorney General looks at a circumstance where it's, hey, we suspect there's a violation, they're just going to fall back on, well, we reasonably likely kind of, sort of, perhaps maybe believed it wasn't going to be in, we were in compliance. And that's going to make it difficult for them. So we do have the right to cure. And I agree that's a policy decision. And I think in this case, it's a good one to say, okay, the goal here is to get you to stop preying on our children and their data. But we also have to give the Attorney General something to work with to get there. But just a thought, and I just want to say, I appreciate all of the work the two House sponsors have done on this bill. They put a lot of time, effort, and energy into it. And at the end of the day, from my perspective, I will, yield to what they deem at this point is most appropriate. And if they are comfortable that we're in a posture where we've got a bill that's meaningful, then, you know, I'm good. Thank you, Madam Chair.
Senator, for me, my first reaction to that is we're trying to change behavior. And the product that I've just heard presented, or the proposal that I've heard presented, I think is a step. Do we get from 0 to 100 on the first go? Probably not, but I hear some movement in a direction. Senator Guile, and then we have one of our virtual witnesses wants to chime in.
Thank you, Madam Chair. I agree with the sentiment that I think we just want things fixed, right? As opposed to some sort of punitive outcome. But I do wonder, what about for repeat violators? What about for continuous, egregious actors? Like what do we do then? Do we keep giving them the right to cure repeatedly, or is there some sort of enforcement then later, some sort of punitive outcome?
Yeah, I think Nicole's actually the
The appropriate
yeah.
person answered. Okay,
Okay,
Nicole, then
right,
we'll
then
call
I'll-
on you. Perfect timing.
Sure. I guess I'll start with the most recent question asked, 'cause I think that's easy to address. The right to cure is only available for folks who are in substantial compliance with the bill. And so if you are repeatedly violating, I would argue that you're not in substantial compliance. Also, for intentional violations, the penalty is up to $7,500 per affected child per violation. So there's a much greater penalty for intentional violations versus negligent violations. So that's taken into account. What I would say about the right to cure in this particular bill, I am an advocate for kids, and so I generally hate rights to cure as well, but we're not going to solve all of the problems with the internet and the online space with one bill. This is specifically a design bill. And so we are asking, the violations of the bill are not when harm has actually occurred, it's prior to the harm occurring. So we're asking people to design their systems in a different way. And so the right to cure, like everyone has been discussing here, I think is appropriate from a public policy standpoint. Now, if a child is actually harmed by what a platform is doing, there are other legal actions that can be taken to address that. This is not that bill. This is trying to prevent harm in the first place. If harm has actually happened, there are other legal avenues that can be pursued.
Yeah.
Was that,
yes, my question was answered. Maybe just one follow-up. Is substantial compliance defined, or we are leaving that for the interpretation of the Attorney General to decide?
So substantial compliance is a legal term of art. It's used all the time. I think it's understood what substantial compliance means. In the bill, it is very specific that the substantial compliance is connected to the data protection impact assessment. So in order to get the right to cure, a business would have to do the data protection impact assessment. So they would have to take a good, honest look at their product, and then ensure that their product is consistent with the definition of the best interests of the child before they got that 90-day right to cure. So the right to cure is not available to folks who do nothing.
Okay. All right. Thank you. Thank you, Madam Chair.
thank you. So we have about 10 minutes left before we're going to need to certainly have the folks that plan to go to the House be able to do that. Did you have a comment now? And then I'd like to open it up to hear from others that haven't had a chance to weigh in.
Briefly, Madam Chair, and it's definitely pains me emotionally to agree with Senator Kramer, but I do have a little concern with when we empower the Attorney General in the good faith, the reasonable and reasonably likely. As a crafty attorney myself, I can see the loopholes being built in. And my concern is, if they just ignore because they believe they don't believe it was reasonably likely, then I'm concerned that we're leaving him with no stick. Again, I'm open for discussion, and I'll say this, that Jared has been, Delegate Solomon has been doing the lion's share of the work. I just offered my weight to the bill because of the importance, and again, we'll defer to Jared at the end. But what I don't, and I'll say this because I've been here, we've been around a long time. There's the whole any bill is better than no bill is absolutely not true. in a case like this, we have to do something substantive and we need to make sure we cross as many Ts and dot as many Is as we can along the way. So I don't want to just accept that because this is what the industry wants and they'll be happy, because that might not be acceptable. So again, and we'll defer to this committee. Thank you.
We have a bunch of folks who have come to participate in this conversation this morning, so I certainly wanted to open it up if anyone feels that you wanted to make a comment or give some feedback on the bill as introduced or on the amendments that have been presented.
Can I just make a
Yes.
comment and kind of a question as well? So Amy Boss, I'm
Can
the
you
direct-
pull one of the mics close so the folks streaming can hear you? Thanks.
Thank you so much. My name is Amy Boss. I'm the Director of State and Federal Affairs at NetChoice. We are a trade association based in DC. So just a quick question, and thank you. The amendment makes a number of improvements, I think, to the legislation and clarifying some of the definitions. Apologies if I've missed it, but one of the definitions that has caused us a little bit of unease is the routinely accessed by a significant number of minors, and whether we have an understanding of what significant means. What does routine mean? I'm wondering if that question can be answered. Yes, let me pull it up here. Page 7.
Start on that. And I know Nicole and Marissa can chime in as well. It's a legal art of standard. And I think the issue is if you put a number in, so using YouTube as an example, if you just use a percentage, YouTube maybe have 2 or 3% of their users as children, but with 180 or 200 million users around the country, around the world, that's 4 million, 5 million kids. So if you put a percent in, you're necessarily going to, you may also bring in websites like, I think the conversation we had in ECM was Napa Auto Parts. They may only have 2% of their users are children, but that may be 10,000 children versus a million or, 10 million. So we chose to leave it, sort of like the pornography standard. We know it when we see it kind of thing. Again, working with business and leaving some discretion here. And Marissa, I don't know if you want to chime in on that. Or Nicole.
I think Delegate Solomon did a good job sort of explaining our concerns about using a specific percentage or a specific number, and that, the viewership for these platforms and products changes so widely depending on what we were talking about, that setting, a 1% or 2% of usership would potentially let a YouTube, be exempt from the bill while pulling in those smaller websites that have, a much smaller number of kids online. So it's trying to provide that flexibility in terms of the enforcement and implementation of the code.
The only other thing I would add, Madam Chair, just not necessarily specific to that definition, but there is, I think, we obviously are always really concerned about small businesses and making sure that they're taken care of. So there's a business definition exemption that if your revenues are under 25 million, this does not apply to you. If you don't sell the information, the only way that this applies to you is if you sell the information of over 50,000 consumers, or more than 50% of your revenue comes specifically from selling data. So we worked closely with the Retailers Association in the state to make sure they were comfortable with all that. So I would say probably 99% of small businesses in the state would probably be exempt from this just right off the bat, because we're not trying to catch any sort of small business that doesn't have, the tech capacity to do this kind of work.
Thank you. We have Andrew in the Zoom room with your hand raised, so you can go ahead. Proceed.
Yeah, thank you. Thank you, Madam Chair, and thanks to everybody. I think I received these amendments last night and woke up to them in my inbox this morning. So I have asked my members to give me feedback as quickly as possible. I certainly do recognize all of the effort and work on behalf of the committee here to try to address some of the concerns that have been expressed. This is a process question, but I have two different PDFs, two different sets of amendments. Is there one document that we should be looking at that I can direct my members? Just a clarification, or are there two PDFs that are both making amendments?
So last night, two sets of amendments were circulated. The reprint that we just walked through today is a consolidation of those two sets of amendments. So after we're done here, I'll circulate to the group this merged document.
Okay, that would be helpful. And we understand the need for feedback. So I'll be providing feedback, as quickly as I can here.
Thank you, Camille.
Hi, everyone. Thank you, Camille. My name's Jordan. I'm with Google. Happy to be here today. And I just want to say thank you to Delegate Solomon and the others that have, and all the work that has gone into this bill. We really appreciate your willingness to work with us. This is something that Google takes very seriously, which is why we came before this committee offering to work in support with members to address the outstanding concerns. We believe there has been significant progress made on the bill. My colleague, Sarah Holland, who's far more knowledgeable, can get into the specifics and can answer any questions, but we really do appreciate the work that has gone into this, and thank you. Sarah, do you have anything you want to say?
Hi, yes, just to echo Jordan's thanks to Delegate Solomon, to everyone that's worked on this bill. This bill is complex, right? And the activities it is regulating are technical and complex as well. And we really appreciate the changes that have been made. They certainly don't reflect every change that we would have wanted to see, but I think that shows that it is a strong bill. We think that it's going to be workable with the amendments that were discussed today, and we'll certainly review the fine print of the revised text. But we really think that it reflects the best of what well-crafted regulation should do, which is really provide strong accountability, protections for kids and families, setting a baseline so that they're protected even if they don't have the time or inclination to use settings, and in a way that really reflects U.S. law, U.S. case law, and what we've seen in terms of smart protections and regulations and privacy laws around the country. So again, I think we just want to say thank you. We think that is with amendments, we think that this is a workable bill and something we think that we can comply with, and we think it's going to change how children are protected in the United States.
Thank you very much. Thank you all. We do need to let folks get over to the House of Delegates. So what I want to say is, first of all, to those that have been working behind, you had one quick comment. I'll let you go real quick before I do my wrap up.
Thank you.
Okay.
I'm Rebecca Snyder with the Press Association. We've worked with Delegate Solomon on this bill and have just a couple minor changes to the section that's now 14506. I think they were sent to you last night, specifically around the profiling piece, because although news media does not target children, does not want to target children, and we've worked through that content piece, we feel in section, I guess now it's section 2, profiling reasonably necessary to provide or support online product. And I think you want to strike request in that, because I'm not sure what request means, but I'm happy to talk to you specifically about those minor tweaks. And I really do appreciate the movement that's been on the bill. Thank you.
Thank you. So want to thank the members of Senate Finance for coming early this morning and being a part of the conversation, and to our colleagues from across the street. Thank you both for being here and for your work. Patrick, thank you so much for receiving all of this input, and want to thank Letitia in my office for setting the meeting up. We're going to continue to have this conversation. We're going to be on the floor of the Senate for good 3 or 4 hours, I'm sure, this morning, and then we'll circle back and check in with members of the committee. And if you all have any additional information, Patrick would absolutely love to get some more feedback from you. But certainly get back to us. This is an issue that we did not want to adjourn without having at least made every effort to get a conversation to see if we could get something that we believe will be impactful. To Chair Wilson's point, though, if we don't believe that we have the right bill, then we shouldn't pass a bill. So we're going to continue to work to see that whatever we put forward, if we put something forward, is doable, enforceable, and that does take care of the issue the bill was introduced to address. So,
Madam Chair, when you mean we, you mean we, the electeds, correct?
yes,
Thank you.
yes. We who have to vote on something if it moves forward. Yes. No, there's Thank you, Mr. Chairman. So glad you were able to come this morning. All right, with that, we're going to adjourn. Thank you all for coming and for your input.